Right. Good morning, ladies and gentlemen. Welcome to another episode of PLA with myself, Nick and Bruno. We've got two questions today, once again, which we'll be separating, one for Bruno and one for Nick, and then they will obviously chip in both of them whenever the need arises. First question is for Bruno, and of course, Nick, you're free to also assist. This is one that's got to do with, we received a question from an estate agent who focuses a lot on leasing, right? And she wants to know an answer regarding leasing mandates, right, and securing commission, right? Basically, what had happened is that there was an early termination of the leasing mandate by the landlord, and now the estate agent wants to know what can she do in terms of claiming commission for the terminated mandate. So the landlord has terminated the mandate, and so how do mandates work with regards to claiming commission around that table, no?
Cool, awesome. So it's actually quite an easy answer. Unfortunately, it's not a solution that's implemented very often, which is unfortunate. And so the reality is that mandates should be in writing. There is this misconception that a mandate need not be in writing, and I've even heard from some estate agents that they prefer it not to be in writing. It makes very little sense to me because a mandate is templated. Just prepare it once off, make sure that it's done properly, and you can use the same template across the board. I've seen some great mandates. I've done some great mandates. You can do it as a little tick box exercise where a person selects their particular option, and it's very, very easily rolled out. So that's just the first thing that I want to mention is mandates should be in writing. It's not that they have to, it's that they should. Why? It's exactly for reasons like this. The industry has certain practices that it relies on. And the reason why people feel that mandates aren't necessary is because, as with sales agents, for example, there's certain commissions that a person expects receiving if they sell a property. So not having a mandate with a specific commission, they tend to fall back on the notion of, yeah, but the industry norm is X%, so that's what I should be getting. The problem is that as businesses, things like industry norms start creating difficulties because businesses identify themselves by being different. And if you're not, if everyone does the same thing, you're never going to actually be able to move your business forward. So as estate agents, there's a lot of practices that, whether they're common or uncommon, is actually uncertain, because as we said, at the moment, one agent charges a procurement fee plus an administration fee or a management fee per month, whereas other agents don't charge a procurement fee at all. They don't even speak about it or mention it. Some landlords have no idea that a procurement fee could actually be charged because it's just not mentioned. They get someone, they put them on the property, and they start charging a management fee. Other agencies, the smarter agencies, or at least the agencies that have made the effort of preparing their mandates properly, specifically mention there is a procurement fee, there is a management fee. If you give me the management, I won't charge you a procurement fee. Now, so trying to bring this back to the question, is a landlord allowed to terminate a leasing mandate? Yes, depending on the terms of the contract. If the contract is month to month, where they hire you out, you rent out the property, you find the tenant, put the tenant there, send them invoices, and he decides, cool, well, job is done, I want to self-manage, he's more than entitled to, because your mandate doesn't say otherwise. To now go back and say, hold on, wait, but it's early termination, I should have charged you a procurement fee. It's too late for that. So my suggestion would be, have a mandate that specifically speaks about a procurement fee, specifically speaks about your management fee, and specifically speaks about the length of time that you're expected to manage the property. If you enter into this contract and say it's a fixed term contract for 12 months, and I will not charge you a procurement fee provided that I manage the contract for 12 months, then at least you've got something fixed. So now the only challenge would be, in terms of the CPA, someone that's stuck in a fixed term contract like a landlord can terminate it early, but then you're entitled to charge a cancellation penalty. which can very easily be, for example, very easily, the procurement fee becomes due and payable if the contract is terminated before the 12-month period or something along those lines. So you can construct your mandate to tie in a landlord, be it by offering him, a lesser commission if he takes you on for a longer period of time, but just make sure that you've got a mandate to cover it.
Well, 100%. They're just highlighting, of course, the importance of having agreements in writing and obviously mentioning all the necessary clauses in terms of your fees and your time and cancellation or breach clauses. So yeah, that definitely covers it for that question. Nice, short and straight to the answer. Nick, we're going to move on with your question. And this one is also, it's regarding a tenant and a landlord. What this one specifically says, it's from the tenant, I believe, and the tenant is saying that, oh, it's from the landlord, actually. The landlord said, so the tenant hasn't paid their rent for June, and then it so happens that the hot water in the premises has stopped functioning. Maybe it's a geyser issue, which the landlord would be subject to fixing. So basically, the tenant hasn't paid for June, and now the hot water stopped working, and now the landlord wants to know, is it necessary now for them to actually go fix the hot water, because the tenant is in breach and they haven't paid for June, and it so happens that now the landlord now is also possibly going to be in breach of the contract. Nick?
Perfect. So yeah, interesting circumstance there. As you say, so the hot water is likely to be a geyser issue within the particular property. I mean, this depends on the property, but it's probably a geyser issue, something that the landlord's going to be responsible for at the end of the day. Okay, they've got to ensure that geyser is working so that the tenant has use and enjoyment. And obviously, in this particular circumstance, tenant hasn't paid rent. The way that the question's framed, I'm assuming that the tenant hasn't decided they're not going to pay rent because of the geyser bursting, and it looks like they didn't pay rent, and then subsequently the geyser's gone off. But these circumstances do happen between landlords, and it can happen in the reverse, where the tenant decides, I'm not paying because the geyser's not working. The circumstances now, this is a circumstance that happens to a lot of landlords, and you are going to find your landlords that's in the circumstance where they actually say, look, he's in breach, I'm in breach, we should leave the situation where it is. Once they pay, I'll make sure that I get the geyser fixed in the circumstances. Some landlords are going to do that. From a legal perspective, which is the perspective we're here to give, it's not a great position. I know a lot of landlords are going to disagree with me. A lot of them are going to say, no, it's what it is. But strictly from a legal perspective, look, as the landlord, you've got to have this fixed. You've got to give use and enjoyment of the particular premises. And when this occurs, you are now in breach of the particular lease agreement. Okay, the tenant can formally give you notice to remedy the breach. Okay, and depending on the terms of your particular contract, they can give you a time period in which to have this problem remedied. Okay, generally that will be 7 days or whatever the case is. Similarly, you as the landlord are in a similar position in that your tenant is also in breach of the lease agreement because they have not paid their rental. And again, you are also in a position where you are going to have to breach your tenants, send them a letter of demand to get them to remedy the breach in that they pay the rental in the circumstances. And depending on whether, what your lease agreement says, if it's on a fixed term, or, do you just want them to pay the rental? Do you want to actually move yourself towards a cancellation, of the lease agreement as a result of the breach? That notice is going to change. And you will have to look at your lease agreement that you've got with the tenant for what period you have to demand for. So the long and the short of the answer is, can the parties now offset their obligations in terms of the lease agreement validity? No, you can't do the offset, but you're both sitting in a situation now where both of you are in breach of the agreement, and you would have to follow due legal procedure by giving a demand to the other party for the remedy to occur. Is that exactly how it works in practice? No, probably not. And that's why I know Bruno was smiling there when I mentioned it, because I know a lot of our landlords will do something different, then actually go ahead and give the demand. They'll probably call the tenant and say, listen, sort it out in a different way. And look, although that's not the strict legal way that's required in law, parties must negotiate and settle and deal with their grievances between one another in whatever way they can, without obviously coming in contravention of any act or performing an unfair practice or something that's illegal. So look, if the parties go ahead and they sit down and negotiate, the landlord says, look, I'll fix it, you've got to make sure that rental's in, perfectly valid.
Yeah, absolutely.
Yeah. So once again, a nice short and answer that's straight to the point. So yeah, the obligations don't necessarily fall away, but of course, in practice, like you say, things do differ. So yeah, thank you very much, Nick. And I believe that does bring us to the end of today's questions and answers. Thank you, everybody, for joining us once again.
Cool.
Thanks so much.
Cheers.